Subcommittee on Workforce Protections will come to order. Welcome, everyone. I note that a quorum is present. I note for the subcommittee that Mr. Tim Walberg of Michigan, Mr. Dan Muser of Pennsylvania, Mr. Fred Keller of Pennsylvania, Mr. Morgan Griffith, and Mr. of Virginia, and Mr. Matt Cartwright of Pennsylvania are permitted to participate in today's hearing with the understanding that their questions will come only after all the members of the Subcommittee on Workforce Protections and the full committee, respectively on both sides of the aisle who are present, have had an opportunity to question the witnesses. The subcommittee is meeting today for a hearing to hear testimony on a sleep at the switch, how the Department of Labor failed to oversee the Black Lung Disability Trust Fund. Pursuant to Committee Rule 7C, opening statements are limited to the chair and the ranking member. This allows us to hear from our witnesses sooner and provides all members with adequate time to ask questions. I recognize myself now for the purpose of making an opening statement. Today we will hear the disturbing story of a major failure of government oversight, a failure apparently going back several decades, and an even more troubling account of how the coal operators and their creditors on Wall Street have left taxpayers to take the hit. Last June, the subcommittee held a hearing about the growing red ink in the Black Lung Disability Trust Fund, the decline of coal production, a reduced level of funding due to the sunset of the Black Lung excise tax, and the resurgence of Black lung disease is pushing the trust fund deeper and deeper into debt. Today, we will explore another important piece of this problem, the Department of Labor's failure to ensure that coal operators are covering their fair share of the benefits owed to miners and their families. When miners are disabled from Black lung disease, they can file a claim for Black lung benefits with the Department of Labor. If a claim is approved, the coal operator that most recently employed them is required to provide benefits and cover medical expenses for the miner and their family. The law requires that operators have insurance to cover benefits for miners and their survivors, benefits that frequently outlast the life of the mining company. If a mine operator shuts down or files for bankruptcy, however, benefits are paid from the Black Lung Disability Trust Fund, which is financed by a small tax on each ton of mined coal. In order to ensure that the obligations of the mine operators do not fall on the trust fund and taxpayers, operators are required by the DOL to either purchase commercial insurance sufficient to cover their current and future obligations, or mine operators can safe-insure as long as they can prove that they have collateral sufficient to cover their obligations. DOL is supposed to oversee that self-insurance program. But the Department of Labor has failed to enforce the mandate that self-insured mine operators set aside sufficient collateral in event of bankruptcy. As a result, the amount of collateral DOL has required from some of these operators is tens of millions of dollars less than their most recent estimated Black lung benefit liability. In 2016, Chairman Scott and then Congressman Sandler Levin asked that the Government Accountability Office to examine the potential exposure of the trust fund from self-insured mine operators who file for bankruptcy, evaluate the effectiveness of DOL's oversight over the program, and make recommendations for improving oversight of the program. The GAO is here today to detail their report. We will also hear from the Director of the Department of Labor's Office of Workers' Compensation Programs to describe the department's efforts to correct this problem. We will hear some troubling findings today. Last summer, we learned that GOA, that of 22 self-insured coal operators, DOL had not reassessed Black lung liabilities or collateral levels of almost half of them in the past 10 years. And one of these operators had not been examined for over 30 years. Today, we will learn that over 6 months after the DOL required self-insured coal operators to update their information, DOL has still not publicly released updated estimates of liability and the appropriate levels of collateral. Today, we will also hear about the consequences of this inadequate oversight. GAO's report found that mine operators in 3 very large recent bankruptcies involving nearly $1 billion in black lung liabilities were required to post only 3% of the needed collateral. At last June's hearing, the GAO made a preliminary finding that the bankruptcies of those 3 companies, Alpha Natural Resources, James River Coal, and Patriot Coal, had resulted in $310 million being added to the trust fund's obligations. But today we will learn that the true number is $865 million, 3 times the original estimate. While taxpayers were saddled with debt, coal executives were walking around with millions of dollars in salaries and bonuses. Following their bankruptcy declaration, one of the bankrupt operators, Alpha Resources, offered executive bonuses of up to $11.9 million to its top executives. Alpha CEO Kevin Clutchfield made almost $8 million in 2014, the year Alpha declared bankruptcy, and then another $1.8 million in 2016 when Alpha emerged from bankruptcy. At the same time, Alpha dumped $494 million in liabilities into the trust fund while providing only $12 million in collateral. As part of the $12 million payment, DOL allowed Alpha's successor to continue to self-insure after the bankruptcy. This fleecing of the trust fund and taxpayers has occurred under DOL's nose despite the department's power to prevent it. The Black Lung Benefits Act gives DOL the authority to hold coal executives personally liable for the costs that were shifted to the trust fund, but this power has rarely been used in the 40 years since this authority was given to DOL. Finally, the department had no functioning appeals process in those rare occasions when they remove an operator's permission to self-insure and the operator appealed. The American people expect good government and deserve answers. I'm disappointed that the department has refused to brief the committee prior to this hearing about its proposal to remedy the self-insurance program. That said, we will be particularly interested in their plans to address this problem, and we'll want to ask GAO whether they think these efforts are adequate. This is a failure on multiple fronts over multiple administrations. What we're seeing here is nothing less than a gaming of the system. The winners are the coal operators and their Wall Street creditors. The losers are the American taxpayers. In other words, the costs of black lung disease have been socialized, and the gains from DOL's failed oversight have been privatized. Today, we hope to learn what happened, how to fix it, and how to prevent it from happening again. Finally, I want to recognize all the coal miners who are attending this important hearing, and thank you for traveling all this distance. I look forward to hearing from our witnesses and thank them for their testimony. I now recognize the distinguished ranking member, Mr. Wright, for the purpose of making an opening statement.
Thank you, Madam Chair. Workers in the mining industry have been an extremely part of the American economy for decades. Congress created the Black Lung Benefits Program to provide benefits to mine workers who are disabled due to black lung disease. As the chair has mentioned, unfortunately, the Black Lung Disability Trust Fund, which is funded primarily through a tax on coal and designed to provide benefits to these workers when responsible employers are not able to pay benefits, has not been managed effectively. According to a study released this morning, which was also mentioned by the GAO, the trust fund has faced financial challenges since it was established more than 40 years ago. In fact, the trust fund has needed to borrow from the U.S. Treasury almost every year to cover its expenditures, which includes financing the debt that the program has generated since its inception. It's our understanding that today's hearing is intended to focus on Department of Labor oversight of the trust fund, specifically related to the coal mine operator insurance program. While there's bipartisan agreement that there have been serious oversight problems facing this program, it's disappointing that my Democrat colleagues have decided to schedule this hearing only hours after the GAO publicly released its report. This has left members and the public very little time to thoroughly go through the findings and recommendations included in the report and limited their opportunity to question today's witnesses more effectively. Program integrity and proper DOL oversight should not be shortchanged and prematurely rushed by this committee. I also take issue with the title of today's hearing. Committee Democrats have once again titled this hearing in a way to deceive the general public and place scrutiny solely on the Trump administration. The GAO made it clear that the trust fund has faced financial challenges since it was established in 1978, not just under the Trump administration, as a misleading title of this hearing might suggest. Additionally, the DOL's oversight of the trust fund and operational failures have persisted for decades under both Democrat and Republican administrations. Let's not forget the Obama administration's war on coal made it harder for coal companies to thrive, while at the same time the trust fund's financial problems continued to grow. As we'll hear from both of our witnesses today, the Office of Workers' Compensation Programs under the Trump administration is taking long overdue proactive steps to improve oversight and management of the trust fund by implementing new processes to reevaluate and reauthorize self-insurance for coal mine operators, requesting additional data on black lung claims and benefit liability, and issuing preliminary guidance to field supervisors and claim examiners. I believe we can all work together with this administration to support common sense, workable, and innovative approaches to ensure DOL is conducting proper oversight and ensuring minor benefits are protected. I'm encouraged by Director Hathaway's work in this area and the ongoing efforts to implement the GOA's recommended reforms to improve oversight of this important program. I want to thank both of our witnesses for being here today, and I look forward to your testimony. Thank you, Madam Chair.
Thank you, Mr. Wright. All other members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on March 10. I will now introduce our two witnesses. Our first witness will be Ms. Cindy Brown Barnes, who is the Director of Education, Workforce, and Income Security with the Government Accountability Office. Ms. Brown Barnes leads the Government Accountability Office team that audited the Department of Labor's management of the Black Lung Disability Trust Fund. She has more than 30 years' experience performing audits of federal agencies. She holds a bachelor's degree in accounting from Howard University and a master's degree in business from Johns Hopkins University. I'm now pleased to recognize my colleague, Congressman Muser, to introduce the second witness appearing before us today. As I understand, they served together in the Pennsylvania legislature. Mr. Muser, you may introduce our witness.
Thank you, Madam Chair. Yes, it is my honor and privilege to introduce to the committee Ms. Julia Hathaway. Julia spent from 1993 to 2011 as a prosecutor in the Pennsylvania Attorney General's office. She then, from 2011 to 2015, did in fact serve as the Secretary of the Pennsylvania Department of Labor and Industry. Pennsylvania is the 5th largest state, and Ms. Hathaway oversaw the 5th largest state agency with over 5,000 employees, 150 offices, and an annual operating budget in excess of $1.2 billion. There, she performed extraordinarily. She set up a website known as Job Gateway that had strong effect on the gaining of nearly 250,000 jobs. She established something called the Keystone Works, something she created, a workforce development initiative, which is still in effect. And she played a very important role in the largest single investment ever made, a private sector investment ever made within the business environment in Pennsylvania. So in 2016, certainly worth mentioning, Madam Chair, 2016 to 2017, Ms. Hathaway was appointed by a Democrat governor to the Commonwealth Court of Pennsylvania as an appellate judge. From September 2017 till the present, she now serves as Director of the Office of Workers' Compensation Programs at the Department of Labor. I can tell you from being a colleague and friend of Ms. Harthway's for a number of years, she's incredibly dedicated, super smart. She's a great public servant. We are fortunate to have her with us today, and she knows coal. So nice to see you, Ms. Harthway. I yield back, Madam Chair.
Thank you. Thank you very much. We appreciate the witnesses for being here today and look forward to your testimony. But let me remind the witnesses that we have read your written statements, and they will appear in full in the hearing record. Pursuant to Committee Rule 7D and the committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. And let me remind the witnesses that pursuant to Title 18 of the U.S. Code, Section 1001, it's illegal to knowingly and willfully falsify any statement, representation, writing, document, or material fact presented to Congress or otherwise conceal or cover up a material fact. So before you begin your testimony, please remember to press the button on the microphone in front of you so that it will turn on and members can hear you. And as you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow to signal that you have 1 minute remaining. When the light turns red, your 5 minutes have expired, and we ask that you please wrap up. We will let both the witnesses make their presentations before we move to member questions. When answering a question, please remember to once again turn on your microphone. I'll now recognize Ms. Cindy Brown Barnes. You have 5 minutes, ma'am.
Chairwoman Adams, Ranking Member Wright, and distinguished members of the subcommittee, thank you for inviting me to discuss our concerns about oversight of coal mine operator black lung insurance. Black lung benefits are generally to be paid by coal operators that are found responsible. However, the trust fund pays benefits in certain circumstances, such as when an operator goes bankrupt. A domestic coal tax is the trust's primary funding source. Today, I will discuss how coal mine operator bankruptcies have affected the trust fund and how the Department of Labor, or DOL, manage coal mine operator insurance to limit financial risk to the trust fund. Federal law generally requires coal mine operators to secure their black lung benefit liability. A self-insured coal mine operator assumes the financial responsibility for providing black lung benefits to its eligible employees by paying claims as they are incurred. Operators are allowed to self-insure if they meet certain DOL conditions, and they must provide collateral. Operators that do not self-insure must obtain commercial coverage. We found that commercial coverage can help limit trust fund exposure from coal operator bankruptcies. However, for self-insurance, we found that DOL failed to protect the trust fund by obtaining adequate collateral from coal operators. On slide 1, we identified 6 coal mine operators that filed for bankruptcy between 2014 and 2016 that DOL had permitted to self-insure. 3 of these bankruptcies resulted in a transfer of estimated benefit liability from the coal operator to the trust fund, and 3 did not. Slide 2 provides some additional details. The bankruptcies of Alpha Natural Resources, James River Coal, and Patriot Coal transferred responsibility for an estimated 3,300 black lung beneficiaries to the trust, which means the taxpayers will ultimately be responsible for their black lung disability payments. We reported to this committee last June that these 3 bankruptcies were transferred around $325 million. However, DOL recently increased this estimate to $865 million as a result of significant changes to their actuarial analysis. In the 3 bankruptcies, DOL had secured just $27 million of collateral. For example, the collateral DOL required from Alpha Natural Resources was about $12 million, and $494 million of estimated benefit liability was transferred to the trust fund. DOL has been challenged collecting collateral from coal operators. For example, in September 2001, DOL notified James River Coal that $5 million in additional collateral was required. However, DOL never received its collateral, and from 2001 until the James River bankruptcy in 2014, DOL took no action to obtain additional collateral or revoke their self-insurance. As a result, this bankruptcy transferred an estimated liability of $141 million to the trust fund. In 2015, DOL stopped monitoring self-insured coal operators as it began developing a new self-insurance process. While DOL was developing this process, several other self-insured operators also filed for bankruptcy, including Cambrian Coal, Cloud Peak Energy, Murray Energy, and Westmoreland Coal. In 2015, DOL had also recommended revoking Murray Energy's self-insurance due to deteriorating financial conditions. However, Murray appealed this decision, and DOL officials said they postponed responding to the appeal until their new self-insurance process was implemented. Murray filed for bankruptcy about 4 years later, and DOL had not revoked its self-insurance or obtained the requested additional collateral. In July 2019, DOL began implementing a new process for coal mine operators' self-insurance that may help to address some past deficiencies if implemented effectively. For example, when setting collateral, DOL would consider an operator's current and future benefit liabilities and an operator's risk of insolvency. A low-risk operator would be required to obtain collateral of 15% of its estimated benefit liability, a medium-risk operator would be 45%, and a high-risk operator would be 90%. However, in February, these percentages were revised to 70, 85, and 100% respectively. These percentages have not been incorporated in formal agency guidance, and we found that DOL's new process still lacks procedures for self-insurance renewals and coal operator appeals. In conclusion, coal operator bankruptcies have already caused substantial damage to the trust fund, and we remain concerned about continued bankruptcies and the looming unsecured black lung benefit liabilities that still threaten the trust fund. While we commend DOL's efforts to address the deficiencies of its past self-insurance process, DOL still has not collected adequate collateral from self-insured coal operators and implemented key internal control improvements needed to protect the financial interests of the trust fund. Thank you. This concludes my prepared statement. I'd be happy to entertain any questions.
Thank you very much. I'll now recognize Ms. Julia Hathaway. You're recognized for 5 minutes, ma'am.
Chairwoman Adams, Representative Wright, Representative Mueller, thank you so much for the kind introduction. And distinguished members of the subcommittee, thank you for inviting me here today to testify about the Office of Workers' Compensation Programs, OWCP's, administration of the Black Lungs Act's insurance provisions. In reference to the title of this hearing, I am pleased to report to this committee that OWCP is wide awake. The self-insurance approval process for coal mine operators has been completely revamped. The process today is robust, it's financially sound, and it's designed to protect the trust fund. I also want to stress at the outset that no miner is at risk for not receiving the benefits they deserve, nor have they ever been at risk. All black lung recipients, miners and their families, will receive their benefits. Congress made certain that benefit payments would never be in jeopardy. U.S. Treasury is required to make advances to the trust fund whenever necessary to meet its obligations. America has always met this obligation. The GAO report highlights the failings of the prior self-insurance approval process and the unfortunate impact on the trust fund. It was a broken process that had been in place for at least 20 years. And I agree, the process was woefully inadequate. One of my first acts when I joined this administration in September of 2017 as director of OWCP was to approve updates to the self-insurance process. The new process was carefully developed in consultation with economists, financial experts, and actuaries. All coal mine operators that had previously been approved to self-insure had to reapply for self-insurance authority. Under the new approval process, coal mine operators are required to provide audited financial statements for the past 3 years, all current black lung claims information, and an actuarial estimate of current and future liabilities. Operators must calculate those actuarial estimates on assumptions drawn from the historical data of the Black Lung Trust Fund. OWCP has now performed financial health assessments of each operator, analyzed the actuarial reports, and calculated appropriate security. Last week, OWCP notified most of the coal mine operators of the new security requirements. These new security requirements thus far will add an estimate $164 million of total security to the trust fund. To my knowledge, this is the most thorough process in the history of the Black Lung Benefits Act. GAO has recognized our efforts, and on behalf of OWCP, I thank them for the acknowledgement of our work. GAO made 3 recommendations regarding our new process, and we have already implemented those recommendations. But let me add, while all these steps are necessary to protect the trust fund, this is not the major driver of the trust fund debt. The current debt, which is just under $6 billion, is projected to exceed $12.6 billion in today's dollars by 2044. Approximately $1 billion of that over the next 25 years is attributed to bankruptcy of the self-insured operators. $11.4 billion is due to accrued interest on advances made from the Treasury. The trust fund has been in debt since it was created. Over 90% of the beneficiaries entering the fund did so during the first 6 years of its existence. Only 10% of the beneficiaries entered in the following 36 years. 12 years after the trust fund's creation, annual revenue collected from coal excise tax was sufficient to fully pay annual benefits and expenses. However, it was not sufficient to finance the debt generated during the program's early years. With the overwhelming majority of beneficiaries entering the trust fund in the early years, a financial structure that provided no initial funding, and an annual variable interest rate on all borrowing, the trust fund has continuously borrowed money to pay interest charges. But again, despite the consistent rising interest cost, no miner is ever at risk of not receiving the benefits they deserve. Thank you, and I'll be happy to answer any questions you may have.
Thank you very much. Under Committee Rule 8A, we will now question witnesses under the 5-minute rule. I will recognize myself now for 5 minutes. Ms. Brown-Barnes, do you think that DOL's revised criteria for self-insurance, which was newly summarized in your report today, is sufficient to prevent unfunded liabilities from being transferred to the trust fund, or does it need to be strengthened?
We commend DOL's new collateral requirements, but they still have to obtain the collateral, and more importantly, they have to provide the oversight and management of the program to prevent the mistakes from the past.
So you believe it needs to be strengthened then?
Yes, and also continue to actually anchor these policies or these procedures in formal agency guidance would also be helpful.
Okay. Ms. Hathaway, according to GAO, you had originally reported that you would require a high-risk operator to secure with collateral 90% of estimated benefit liability, a medium-risk operator to secure 45%, and a low-risk operator to secure 15%. Then this month, DOL suddenly changed that, telling GAO that you now plan to revise these percentages to 100%, 85%, and 70% for high-risk, medium-risk, and low-risk operators, respectively. Now, yes or no, did you adopt the higher levels of required collateral? Yes or no?
We did adopt.
You did? You did. did you decide to adopt those higher levels? Or when did you decide to adopt them?
So the initial levels that you read, the 15, 45, 90, they were sort of initial placeholders. This has been an ongoing process, but it was relatively recent. In the last couple of months, we've been discussing as we neared the end of the completion of evaluating all of the self-insured coal mine operators, what would be the appropriate amounts. And in numerous discussions, with lots of help from our actuary, we developed that we thought it should be higher. So a low risk would now be at 70, a medium risk would be at 85, and a high risk would be at 100. And when we sent out the letters for the collateral amounts, that's what we've indicated to each of those companies.
Okay, you state in your testimony that you've issued 14 decision letters. What was the range of collateral required of the coal operators in those decision letters that you issued?
So out of the 14, 2 of the coal operators were not accepted to continue to self-insure. 6 of those operators showed low, so we're asking for 70% of the collateral. 4 were medium, and 2 were high, with 100% being requested from them.
Okay, so that was going to be my question. You said 2 were high?
2 were at the high level, yes.
Okay. And how many medium and how many low did you say?
4 were at the medium level, 6 at the low level, and then there's 2 that were not agreeing to self-insure.
All right, can you provide the committee with copies of those 14 letters?
I believe so. We'll check with council, but I don't think it's a problem.
Okay. Ms. Hathaway, I described how the corporate directors of the 3 co-operators who saddled the fund with an additional $865 million in collateralized liabilities personally profited from their bankruptcies to the tune of $10 million. So do you think that was right?
Well, these are clearly, had the appropriate collateral been secured before the bankruptcy, this wouldn't have been a problem. And as I've indicated, this was a broken system and has been for 2+ decades. Had the correct collateral been collected, then it wouldn't have been an issue, but unfortunately it was not.
What actions has DOL taken to protect the trust fund in bankruptcy proceedings and keep coal executives from profiting at the expense of taxpayers?
So this, I think, is a huge step. This is a step where to prevent, regardless of what occurs with a coal mine operator, you have the sufficient collateral up front protecting any future claims with respect to their employees that may develop black lung and fall into need of benefits and have a claim. That, I think, is the most critical step. The other tool available is to fine a coal mine operator if they don't properly secure. And we can do that on a daily basis. That had not been done in the past. We do intend to do it in the future if they do not properly obtain the correct collateral or go to commercial insurance.
Thank you, ma'am. I'm out of time now. So I'm now going to recognize Ranking Member Wright for the purpose of questioning the witnesses. You're recognized.
Thank you, Madam Chair. Ms. Hathaway, the jump to $865 million, was that due solely to the fact that collateral was not collected?
The 800?
The increased $865 million, that was a huge jump.
Yes. So the initial estimate that was done, they were done 3 different companies over the course of a couple of years from about 2015 to 2017. We started to see a trend where claims were increasing, both the submission of claims and the acceptance of claims. And sometimes that occurs after a bankruptcy, but this particular trend was sustained. So we went back and recalculated the collateral or the potential liability of those 3 companies. That trend line changed the dynamics. That, in addition to now we were 2 years later, there was a different discount factor to apply to it, and there was one coal mine operator, when the original projections were made, did not calculate in future claims. Those primary three factors increase the amount, but we wanted to be completely transparent and upfront with what the actual liabilities were. So we redid the calculations to say, going forward, this is what we think the impact to the trust fund will be.
And I commend you for that and also for the steps you've taken. But speaking of trend line, what is it now?
The claims are still going up, both the submission of claims and acceptance of claims. Our last calculations have all been done as September 30th of 2019.
Okay. Ms. Barnes, the report released today notes that between 2014 and 2016, coal production decreased by 1 billion tons, down to 728 million tons. Now, what impact does this decreased production have on Black Lung Disability Fund? Doesn't declining production contribute to this mess?
It does contribute to it, and the declining production decreases the revenue.
Realizing, I'm going back to you, Ms. Harthway, realizing that that connection exists, isn't it at least incongruous to be, casting blame on the coal companies when you had a president of the United States that for 8 years launched a war on coal and made it as difficult as possible for them to thrive, wanted them to die, wanted them to fail, and now we've got this huge increase in liability. Wasn't it more, during that period, wasn't it more difficult for the coal companies to operate?
There's no question that between 2014 and 2016, 8 coal companies declared bankruptcy. The 3 that were being talked about today that are in the GAO report happened during that time period, and the liabilities for those, let me get the full picture. There has been 4 bankruptcies since 2017 as well. That's a total of 12 bankruptcies. But currently, 6 have entered, those liabilities have fallen on the trust fund. 3 bankruptcies have emerged from bankruptcy, and those bankruptcies will not impact the trust fund. There's 3 other bankruptcies where we don't know yet. So clearly, the economy and the impact of those 12 bankruptcies have had an influence. But as I've indicated in my opening, the main driver of the debt is still the interest charges on the outstanding debt.
Last thing, and I'm about out of time. You indicated earlier that you're in agreement with the recommendations from GAO. Is there anything you disagree with in their report?
No. The recommendations were well received. They were activities that we were planning on in many respects. Everything should be very transparent. The letters that we sent out, we told all the coal mine operators that if they want to appeal this, it must be done within 30 days. My intent is to have any response back on those appeals within a total of 90 days. Every coal mine operator have also been told that they will have to reapply for self-insurance status in a year, and that they need to get us all documents 3 months prior to the end of that expiration period. All of those things were recommendations that the GAO also made, and we have already implemented.
Great. Thank you. Thank you, Madam Chair.
Thank you. The gentlelady from Washington, Ms. Jalapal, you're recognized for 5 minutes.
Thank you, Madam Chair, and thank you both for being here. I think we all understand the backbreaking work that miners do. My husband is from Pennsylvania, and his grandfather and his grandfather's brother were both coal miners, and I've heard a lot of stories about that work and what it meant to come home after a long day and all of the health effects that went along with that. So I'm grateful that Congress passed the Federal Coal Mine Health and Safety Act and the Black Lung Benefits Act to make sure that former miners who cannot work due to black lung disease are cared for. It's only logical that mine operators are responsible for paying for these costs since their mines caused the miners' lung disease and their companies profited from the miners' labor. But too often, as we're seeing, these mining companies are forcing taxpayers to foot the bill for their failures. Ms. Brown-Barnes, you're the Director of Education, Workforce, and Income Security at GAO. You've testified today that the Department of Labor's Office of Workers' Compensation Programs has permitted mine operators to avoid paying for workers' compensation, and instead, many mine operators cut costs by a process known as self-insuring. Is the DOL adequately screening companies that apply for self-insurance?
Under the former process, they didn't, but they've taken some steps to put this new process in place, but it still remains to be seen in terms of the oversight and the management of it.
Mm-hmm. And as you know, Alpha Natural Resources executives only posted $12 million of the company's reserves to cover $495 million in liabilities, and yet Alpha's executives managed to pay themselves tens of millions of dollars prior to and during bankruptcy proceedings. If the DOL were to use its current legal authorities to sue mining executives to recover losses due to underfunded self-insurance, do you expect that those executives would do a better job of collateralizing their obligations?
Yes, and that would have to happen before bankruptcy, because after bankruptcy, DOL has to get in line with the other unsecured creditors.
Exactly. It's too late by then.
Yes.
And the DOL has used this tool before, and it recovered money for the taxpayer. In light of the declining financial health of the industry overall and the egregious abuses by mine company CEOs who managed to escape their liability towards workers while getting millions of dollars in payouts, it seems like it's time to end self-insurance and simply require operators to rely on commercial black lung claims insurance. And so, Ms. Harthway, you direct the Office of Workers' Compensation Programs. Can you give us any good argument for why, given what the GAO has revealed, there should continue to be a self-insurance program? Why shouldn't all operators be required to just purchase commercial insurance?
So the statute itself allows for self-insurance, so we're following the law by administering it. But I do understand your concerns, and you're absolutely correct. Had the appropriate collateral been secured, then it doesn't matter that they're self-insured because the appropriate amount of collateral has already been secured. Right. That's why these reforms are so important, and that's why we have done them now, to ensure that regardless of whether it's commercial or self-insurance, the appropriate amount of money is there to pay future claims.
Right, and that's right. I mean, I agree with you that it's necessary to have the collateral, but why not just ask, I guess I didn't hear an answer to why not just ask for commercial insurance instead of, are you saying it's because it's in the law that it's allowed, and so you're just following the law as it is?
Correct.
Okay.
Correct.
And so the DOL may, under the Black Lung Benefits Act, impose personal liability on CEOs and high-level officers of the mining company when the company has not complied with its obligation to provide sufficient insurance to cover its liabilities to the program. Prior secretaries of the DOL have successfully pursued those actions, including Secretaries Brock and Donovan, who served under President Reagan. But under this current leadership, the DOL doesn't seem to have done that. Is that correct? Has the DOL enforced this provision and required mining company executives to pay their fair share instead of putting it on the taxpayers?
So I noticed you went back to the Reagan administration. I could not find an instance where daily fines were administered against a coal operator for not securing the appropriate insurance in the past 20 years.
But is there a reason you wouldn't do it? It's allowed by the law. So
No, I think it's a valuable tool if they do not secure the appropriate insurance or put up the required collateral.
because you could do that right now from the executives of Alpha, Patriot, or James River. Those are all 3 self-insured companies that recently went bankrupt. That would be a great way to ensure that those companies actually pay into the fund that they knew from the very beginning that they were supposed to pay into.
I could not impose a fine on them now, post-bankruptcy.
But you could have. Anyway,
Past
my time,
administration could have.
yeah, my time has expired, but thank you so much.
Thank you very much. I'll now recognize the gentlelady from North Carolina, Ranking Member of Education and Labor, Dr. Fox.
Thank you, Madam Chairman. Ms. Harthway, I think what you were trying to say that didn't get heard because you were interrupted is the previous administration could have issued those fines. Is that what you said?
Yes.
Good. I think it's really important that we determine that most of these problems occurred in the previous administration, the Obama administration, but they do go back for over 20 years, as you've said. So both Democrats and Republicans are culpable. It is really unfortunate that this has not been looked at in the past, but much of what happened in the Obama administration in trying to put coal companies out of business exacerbated the problem. Ms. Harthway, in your comments included in the GAO report released today, you mentioned that the Office of Workers' Compensation Programs, OWCP, began efforts to address concerns about coal miner operator insurance oversight in 2015. Could you provide additional details about the timing and implementation of improved processes and changes that have been implemented since you were appointed as OWCP director? And by the way, if you have any ideas about why your predecessor didn't do any of these, I'd love to hear those.
So to give you an understanding of when the bankruptcies started to occur in 2014, 2015, and 2016.
Under the Obama administration.
Yes, yes. The career of individuals in our office recognized a problem, and they started looking at it. When I came on board in September of 2017 under the Trump administration, one of the first things I did was support them from a leadership point of view to implement this actual process.
So the leadership in the Department of Labor did not support the career people in implementing the proper policies.
I can only speak that I did that at the time I came in. It was not done, it had not been implemented before. When I came in, I signed a directive to move forward in putting a new process in place. Myself and the team have worked very hard to get this in place. It is a long time coming, but I think it's good news that it's now there.
Thank you. Ms. Harthway, what is the primary source of Black Lung Disability Trust Fund funding? I think you've alluded to this before. How much of an impact do coal mine company bankruptcies have on trust fund solvency compared to other challenges such as the interest? Again, you've alluded to this. Are miners and survivors' benefits ever at risk? You've told us, I believe, that they are not, even when the trust fund faces financial and administrative challenges.
Yes, the bankruptcies have had an impact, but if you look at it in the totality of what's happening, it's less than 10%. More than 90% of the impact to the trust fund has been this accruing interest. It's really government borrowing with government and charging interest on it. The coal excise tax has been able to pay since 1990 the benefits and administrative cost for the Black Lung program, but they have not been able to make up the interest charges that accrue annually.
Thank you. Ms. Brown-Barnes, when GAO provided the draft report to the Department of Labor for review and comment, what was the department's reaction to the recommendations you outlined? Was the department aware of the concerns that the report detailed regarding oversight of the Black Lung Disability Trust Fund? And did the department note that there are ongoing efforts to correct these processes?
Yes. As far as the recommendations, they agreed with all of the recommendations, and they noted that they had already started taking some steps to address them.
Thank you very much. Ms. Harthway, OWCP is in the process of overhauling how it determines collateral amounts required for self-insured coal mine operators. Can you compare the new criteria with the criteria previously used and discuss why using actuarial analyses to assess the insolvency risk of operators and future Black Lung benefits liabilities is important?
Yes, thank you for that question. This is a key game changer with respect to protecting the trust fund. Actuarial reports were not asked for in the past. There's no way without an actuarial report to have an indication as to what future liabilities will be, both for current and future employees that may come down with black lung disease. But also, we are not allowing the coal operators to provide their own actuarial reports based on their own factors. They have to accept the factors we've given them. For example, if it falls into the trust fund, it is what the trust fund has experienced in terms of medical cost. So we gave them the factor in calculating the actuarial amount. They must use our medical cost. They must use our claims information so that, one, every operator is using the same factors when calculating their actuarial amount, and they're not using their own. That's one of the key factors. In addition to that, though, we have 3 years of financial records. We have the claims information.
We're out of time, ma'am. The gentlelady's out of time. Thank you.
Thank you, Madam Chairman.
I want to recognize now the gentleman from Virginia, Chair of Education and Labor, Mr. Scott. You're recognized 5 minutes.
Thank you, Madam Chair. I think there's one thing we can agree on with the ranking member, and that is that both parties helped to get into this mess. So if we could just look forward to see how we can get out, we don't have to go through the blame game and all that. The ranking member, the gentleman from Texas, mentioned that this hearing is being held right after the report was issued. I'd like the record to reflect that my staff has advised me that an embargoed draft of the report was available to the Republican staff 2 weeks ago, and the final draft was made available to the Republican staff on Friday. If there's a miscommunication, then we can deal with that. Ms. Hathaway, looking forward, what mechanisms are now being used to enforce the collateral requirements?
So we just sent out the letters with the new collateral amounts for each of the operators. They have 30 days to respond to that, but we will not grant them self-insurance status until we have the appropriate proof that that collateral has been secured.
And what happens if they don't respond?
Then they will have to either get self-insurance or they can be fined.
Okay. And is
I'm
anything?
sorry, I said self-insurance. They'd have to get commercial insurance or be fined. I misspoke.
Okay. Is anything being done to go after officials? It's my understanding that the officials of companies are jointly and severally and personally liable if they did not put up appropriate collateral. Is anything being done now to go after the officials?
So once a operator falls into the bankruptcy courts, our office is active in trying to negotiate as well as put forward as any other creditor of what is to be paid, but that's all we can do at that point.
Well, that's if the company is in bankruptcy. Are the officials in bankruptcy too?
No.
They are jointly, severally, and personally liable. Is that right?
Yes, I believe so, but it's my understanding through the bankruptcy court, it would be still very difficult had we not done fines ahead of time to collect that amount.
Okay. Is any consideration being given to go after the officials at this point?
In that sense, no, sir, because the bankruptcy courts, there are proceedings in which our attorneys are involved with respect to that, but our focus is to get the correct amount of collateral now, so that issue isn't in front of us.
Okay. You indicated that the taxes were paying the benefits, but not the interest that's being accrued. Is that the old interest rate that was paid 2 years ago, or the lower interest rate that's being collected now?
So every year, the interest rate changes.
Well, yeah, no, the tax. The tax was not extended.
So we don't know the end of the borrowing from this year yet, but we did not have to borrow additional funds last year when the tax was reduced. to pay benefits and administration expenses. To pay the ongoing interest, a great deal had to be borrowed.
Okay, does the Department of Labor support a long-term extension of the tax rate?
No, that's not a position here. Tax is a factor to be considered, but it's not the only factor to be considered in the solution of the debt fund.
Well, one of the problems with the tax not being sufficient to pay the bills is that you have actually three possibilities. Either we continue to run up debt, and as you indicated, it's headed towards, what, 20 billion if we don't do something, or we can just let the taxpayer continue to subsidize. The third unfortunate possibility is that we cut benefits. Were benefits cut in 1981?
I'm not certain, sir, but I don't think there's any discussion of cutting benefits. And the real issue on the debt is government borrowing from government. It's the interest charges from the Treasury, which are charged each year. The amounts are calculated, but that amount isn't technically paid. It just shows up on the spreadsheet.
Let me ask one quick question. Is there any effect on the trust fund caused by the increase in the progressive massive fibrosis, the more severe black lung? Is that having an effect on the trust fund?
So we've not been able to see a statistical effect yet on that. We're certainly aware of the reports with respect to that, but it hasn't shown up in our data in terms of the number of claims, the length of claims. We are seeing an increase in claims, as I indicated before, but I don't have more data that I can pinpoint a reason for that.
Thank you, Madam Chair.
I'd now like to recognize the gentleman from Pennsylvania, Mr. Keller. 5 minutes, please.
Thank you, Madam Chair, and thank you to the panel for being here today. Do have a couple questions regarding some things based upon the report. But first, Ms. Harthway, under the Office of Workers' Compensation Programs' new process for authorizing coal mine operator self-insurance, what types of documentation are coal mine operators required to provide as part of an application?
So we ask a lot of more detailed questions in our application. We ask for 3 years of audited financial statements. We ask for the actuarial report. If they want to send their own actuarial report, they're welcome to do that. We ask for all current claims benefit information that have been paid out over the past 3 years. And we have a tool in which we're analyzing, based on all that financial information, the low, medium, and high-risk categories that we place coal operators in.
Okay. Just to follow up on that, you say you require this now. Were these always the requirements, or were there new additions based upon the GAO or other recommendations to strengthen the program oversight?
So these are strengthened. There's always been a request for financial documents, and the big problem here is that so much time went by without there being a review of this. So the earlier questions and testimony is accurate. Years would go by, and no one had reviewed the self-insurance process. So even if you ask for financial information, it may have been 10 or 15 years old. One of the key aspects of this new process is this will be done annually, and we're going to get quarterly financial reports from all the operators going forward.
The operators, and you talk about having the information available. Of course, many companies are organized in different ways. Are these companies privately held companies? Are they publicly traded companies, or are they some of both?
I believe they're a mixture, sir.
They're a mixture. So actually, a publicly traded company then would have information more readily available?
Correct.
Okay, just sort of trying to understand that, because I know we all talk about how we hold people accountable and who owns these companies and makes the money from them. And a lot of times it may not just be an individual, but it might be something that's publicly traded on the stock market. Therefore,
Correct.
owners could be pension funds and all the other kind of things of some of these bankrupt companies.
That's correct.
Okay, thank you. Ms. Brown-Barnes, your report mentions that the Black Lung Disability Trust Fund has faced financial challenges since it was first established over 40 years ago. If there are not sufficient funds in the trust fund to pay benefits, how does the fund pay for these benefits?
The benefits are not in jeopardy. They are paid for. That's under the act that they would be paid for.
But where do we generate if the fund, or let me ask this question. How often has the fund had to borrow from the Department of Treasury's general fund to be solvent, or have they had to do that?
No, they've had to do that. They've had to do that almost since the beginning
Since the beginning of,
Yeah.
of the act?
of the trust fund.
Of the trust fund, okay. The other question, I guess, Ms. Brown-Barnes, the GAO examined 8 coal mine operator bankruptcies in a report. How many of the bankruptcies resulted in benefit liabilities being transferred to the Black Lung Disability Trust Fund? Do we know that?
We know about the 3 that we talked about, James River Coal, as well as Arch and Patriot. So we do know about those 3. But then there are 4 other ones that we do not have complete estimates of. We have some information about Westmoreland Coal. We've heard recently that was $17 million. And then there are others that did not, 3 others that did not result in benefits being transferred to the trust fund.
Okay. How many of the coal mine operators were self-insured compared to the commercially insured? Do we know that?
We know that out of the 8, 2 were commercially insured. Those benefits were not transferred to the trust fund. Then there were the 6 that I had in my chart. And out of that 6, 3 of the self-insured were transferred to trust fund. The other 3 self-insured were reorganized, and their benefit liabilities did not end up on the trust fund.
Okay. And another important part, were these privately held companies or publicly traded companies, or privately held, or don't we have that information on these ones that were bankruptcies?
Yeah, I could get you some of the details of that to give you a fuller picture.
I appreciate that. Thank you.
Sure.
Thank you.
Thank you, sir. I want to recognize the gentleman from Virginia, Mr. Klein. You're recognized 5 minutes.
Thank you, Madam Chair. This subcommittee had a hearing back in June on advances in protections for minors, and I'm glad we're following up with that with today's hearing. As I mentioned then, Washington and Lee School of Law, which is located in my district and has such esteemed alumni as the gentleman from Virginia, Mr. Griffith, who is here, has an advanced administrative litigation clinic for black lung. This clinic assists coal miners and survivors who are pursuing federal black lung benefits. They've represented roughly 200 clients since being established in 1996 and has a success rate of 5 times the national average. Additionally, other Virginia schools are working on research for ways to better health and safety practices. I'm proud that my home state of Virginia is active on these issues and is a great contributor to raising the standard of care. And I also want to thank the chairman of the full committee for his remarks, and I like his tie today as well. The issues that the Black Lung Trust Fund is having are serious. Proper oversight over the distribution of the funds is needed. Workers who need services should be taken care of, and any misallocation should not be tolerated. With health care and safety measures improving, we're not in the same circumstances we were when it was set up, so we should continue to evaluate and adjust oversight over these funds to ensure minors are being taken care of. So with that, I'll ask Ms. Harthway, can you tell us what enforcement actions are OWCP prepared to take against coal mine operators that do not comply with the new self-insurance authorization protocol?
So I think the most critical thing is we will not give them self-insurance status until they show us appropriate proof of the collateral that we told them they have to secure. So that's first and foremost. They won't have the approval. If they continue, if they don't either get the sufficient collateral or get commercial insurance, there are fines that we can assess against them.
That was my next question. What enforcement action can be taken against the operators that don't maintain sufficient coverage, continuous coverage, and your answer is fine. There's certain levels of fines that are available. What role does data from the NCCI play, the National Council on Compensation Insurance, play in OWCP's oversight and enforcement of coal mine operator commercial insurance policies?
So thank you for that question. The other aspect of this is the commercial insurance, and we are to have oversight of that as well. NCCI provides us with a data feed, so we get notifications of when a policy has been canceled, revoked, not renewed. There are currently, I believe it's 455 coal mine operations. We have gone through to start checking all of their current insurance. We're about halfway, a little more than halfway through of checking current commercial insurance for each of those. We are looking at the data feed from NCCI, and we are developing in our computer system a way to have more checks and balances so that we can be very proactive as soon as something happens. I believe in the report there were 2 commercial insurers that initially the GAO found that appeared their commercial insurance had lapsed. When we looked into it, it actually had not lapsed. They had always had commercial insurance. But I agree, this is an oversight responsibility that OWCP has, and we're putting steps in place to make sure that we also monitor that.
Are there limitations to the data, and what plans, if any, does OWCP have to address the limitations to ensure that the operators are maintaining continuous coverage?
So I think there's some technical limitations in working a robust system, a computer system that will give us these quick alerts. But I think we have the ability, because we're working through each of the 455 coal miners, to monitor this with our current staff at the time. So I wouldn't say it's not without challenges, but I think the staff is more than up for those challenges.
Thank you. Thank you, Madam Chair. I yield back.
Thank you very much. The gentleman from Michigan, Mr. Wahlberg, you recognize for 5 minutes.
Thank you, Madam Chairwoman. This brings back memories of when I chaired this subcommittee for 6 years. And while there's certainly, as I recollect, blame to go around on both sides, because my chairmanship was during the time of the past administration with what we often call the war on coal that went on, making it more difficult for the resources in the trust fund to be managed appropriately and to meet the needs that we had. Yet I'm thankful that it appears that there is some recognition that that is not acceptable, and management has to be done to make sure the financial resources grow and meet the needs of miners. And we want to see that take place. So I appreciate the hearing today and appreciate the witnesses being here. Ms. Brown-Barnes, approximately how many beneficiaries are currently receiving black lung benefits?
There's over 25,000.
25,000?
Yeah.
Receiving the benefits right now?
Yes.
Of these beneficiaries, what % of their claims are paid for from the Black Lung Disability Trust Fund, and what % are paid for by responsible coal mine operators? Do you have a figure on that?
I can get you the figure on that. There, it's more than half that are paid by the trust fund.
More than half?
Yeah, but I can get you some exact numbers.
The rest would be by coal mine operators that are proving some responsibility.
There's some by coal mine operators, and then there's a portion where there's some interim benefits, and that's also paid by the trust fund.
The trust fund.
Yeah.
In what cases does the Black Lung Disability Trust Fund assume responsibility for benefit liability?
When there's no, or a responsible coal mine operator available, or a responsible coal mine operator is not paid because of bankruptcy.
Okay. In addition to the coal mine operator self-insurance program, GAO examined OWCP's oversight of the coal mine operator commercial insurance program as well. Was GAO able to determine what risk coal mine operators who had a lapse in commercial coverage posed to the trust fund?
We didn't find any, in terms of any benefit liabilities being transferred to the trust fund from commercial insurers.
None at all.
No, what we found some problems with in the data, we saw where there was at least one of the operators that didn't have adequate coverage, or it was not at least indicated in the data that we could get from Department of Labor, and they did have to go back out to that operator to make sure that they extended their coverage.
Okay. When implemented by the OWCP, will GAO's recommendation to improve data collection and monitor compliance allow this risk to be evaluated more fully?
It will, if the oversight is there and the quality checks that they're going to do to their systems are actually implemented.
Okay. Ms. Hathaway, do you have any addition to that?
I'm here letting this committee know, so sorry, that we are have implemented a number of these reforms, and we are monitoring this. I think that's good news for the first time in a couple of decades to have this kind of oversight at the both commercially and self-insured. To answer your previous question, I do have the number, what we call chief beneficiaries in the trust fund. There are currently 13,040 chief beneficiaries in the trust fund.
13,040. Okay. Thank you. I yield back.
Thank you very much. I want to recognize the gentleman from Pennsylvania, Mr. Cartwright. You recognize 5 minutes, sir.
Thank you, Madam Chair, and thank you particularly, Chairwoman Adams, for inviting me to join this subcommittee today and considering some of the most urgent issues facing America's minors and facing their benefits. As this subcommittee has uncovered with the help of GAO, thank you for being here, Ms. Brown-Barnes, the coal industry's risky self-insurance practices have endangered those benefits. And the mismanagement of funds and the lack of oversight by the Department of Labor have made a bad situation worse. And we'll talk about that. I also want to highlight another barrier standing between disabled minors and their health benefits: the deceptive practices coal companies often use to prevent minors and their families from receiving the benefits they need and deserve. The doctors paid by the coal companies systematically misdiagnosing minors with diseases other than black lung, and the company lawyers withholding medical evidence that minors could use to defend their claims by proving that they have black lung. As such, I will be introducing the Black Lung Benefit Improvement Act to ensure that minors have access to unbiased medical evidence, ample representation, and up-to-date benefit payments. Senator Bob Casey of Pennsylvania has already introduced this bill in the Senate, and I do look forward to working with this committee to advance this in the House very soon. My hope is that we can ultimately bring a package of bills to the floor addressing the various challenges facing coal country. Now, we've been talking about self-insurance here this afternoon, and with my remaining time, I'd like to ask the witnesses a couple of questions about that. Murray Energy has been mentioned. It filed for bankruptcy in October of 2019. That made it the 8th coal company in a year to file for bankruptcy, 8 within a year. That means between 2018 and 2019. And we have twice heard, in the space of the time I've been sitting here in the subcommittee, intoned the expression war on coal. I think we can all agree there hasn't been a war on coal going on in 2018 and 2019. Nevertheless, 8 coal company bankruptcies, obviously, and it's as plain as the nose on everybody's face, it has to do with the low price of competing natural gas. So casting blame about whose administration is at fault, it doesn't make any sense. Ms. Brown Barnes, I understand the Department of Labor ordered Murray Energy to end self-insurance in 2015. Nevertheless, Murray Energy continued to self-insure until filing for bankruptcy in 2019. Can you explain what went wrong there?
Murray, they appealed the decision, and the Department of Labor, they had postponed responding to the appeal because at that point they had started looking into their new self-insurance process, and they wanted to wait until that was implemented. But then in the interim, Murray filed for bankruptcy last October.
Right. Why was that appeal never adjudicated in the intervening years until it went bankruptcy?
That the Department of Labor would have to answer. Yeah.
Well, what are the consequences of that Murray bankruptcy for the Black Lung Disability Trust Fund, Ms. Brown Barnes?
The consequences are those liabilities would be transferred to the trust fund and be on the American public.
Well, how about you, Ms. Harthway? Can you speak to the consequences of the Murray bankruptcy for the trust fund? You was talking about 10%.
Currently, of none of their liabilities have fallen into the trust fund. Currently, Murray is continuing to pay benefits on their black lung claims. So nothing has impacted with respect to Murray on the trust fund yet. It perhaps may in the future, but we don't know that yet.
What's your answer about why that appeal was never adjudicated between 2015 and when they filed for bankruptcy in 2019?
So, as I indicated before, Murray's collateral was determined back in 1996 and had never been reviewed until 2015 when their self-insurance status was revoked. At that time, they asked for reconsideration. There was no enforcement action, and I can't explain to you why. And then early 2017, it's discovered that they only commercially insured some of their operators and not others. We are now a couple of years down the road. We have started to develop this new process that was supposed to be and is much more robust. So we put all of the self-insured operators into that process, including Murray, but they subsequently filed bankruptcy.
So the miners continue to get the benefits, but the American taxpayers take it in the neck. Thank you, Madam Chair. I yield back.
I want to recognize now the gentleman from Virginia, Ms. Griffith, recognized 5 minutes.
Thank you, Madam Chair, and thank you so much for holding this important hearing. Several people have said it, but it would be good to repeat, Ms. Harthway. All the folks who are receiving benefits, they're in no danger of losing those benefits. Is that correct?
They're in no danger of losing
All right.
their benefits, none.
Now, I have a question, and I think I know the answer, but I'll ask Ms. Barnes. In your chart, in your testimony, it talks about Alpha Natural Resources, which was headquartered in my district, so I don't want to make everybody aware that that was in my district. It says amount of collateral time of bankruptcy, $12 million, estimated transfer of benefit responsibility to the trust fund, $495 million. Now, the $12 million did not represent Alpha's net assets. That, if I'm reading it correctly, and you correct me if I'm wrong, that $12 million was how much they had set aside to pay for black lung claims. Is that correct?
Yes.
Okay, that's what I thought, because they came out of bankruptcy and they obviously had more assets than $12 million. So here's my question to either or both of you. One, did the Department of Labor go into the bankruptcy court with these numbers and ask for some of that money that was out there to be put into the trust fund, since there was a $494 million shortfall? And is there a process for the Department of Labor to go in on into the bankruptcy hearings? And the reason I raise this question is a former CEO of Alpha Natural Resources actually went into the bankruptcy court because originally they were going to zero out, as I recall it, the pension benefits as well, and he filed in the bankruptcy court a petition that they at least get some of the pensioners get some of their money, and he was successful in getting them some of their money. So the question then becomes, because part of it ended up with the equity firms, and I don't know all of the transactions, but they came back out of bankruptcy as two different entities. Yeah. So there was money left over. Did DOL ask for that money, and is there a process for them to do that?
department would have to answer that.
So in a bankruptcy proceeding, yes, we are one of the creditors, DOL, of OWCP, and on behalf of the trust fund, one of the creditors that puts forth the liabilities or the what's due and owing. It's on current, not the future. This is why setting the collateral is so critical, but we are part of that process along with all the other creditors,
Right.
to try and get and recoup as much as possible for benefits.
Do you know if you all made an attempt to get more than the $12 million out of Alpha Natural Resources? And you may not know that answer today.
And I will have to get back to you on that. I know as part of the settlement agreement that we were in and came out of the bankruptcy, that they had to maintain some of their current benefits and pay for them. But I'd have to get the specifics for you. I don't have that
If you
offhand.
could get the specifics for Alpha, James River, and Patriot, I would greatly appreciate that, so that I, can have the information. And then if there is something that your team thinks that we need to do legislatively to make it possible to, and I don't want to get in front of, a lot of other people, but this is an important benefit to the miners who have black lung. Is there something that we need to pass legislatively to make sure that we are getting some sort of a priority in the bankruptcy system for these monies? Can we do that?
Yes, sir. Yes, sir.
I appreciate that. I do appreciate that you all have testified today. There are a lot of things that can be done. I'm going to be taking a look at Mr. Cartwright's bill. I do think we have to change some of the rules to make sure that the miners are getting a fair shake in the process. It takes way too long for the miners to get an answer in these cases, and we've got to figure out a better way to do that. But I also want to make sure we get this information on the bankruptcies to try to make sure that the taxpayers don't, as Mr. Cartwright said, don't take it in the neck quite as bad as they currently are. At the same time, I'm glad that the miners are going to get all of the benefits that they deserve. Thank you, and I yield back.
Thank you very much. I want to remind my colleagues that pursuant to committee practice, materials for submission for the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing, preferably in Microsoft Word format. The materials submitted must address the subject matter of the hearing. Only a member of the subcommittee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages each. Documents longer than 50 pages will be incorporated into a record via an internet link that you must provide to the committee clerk within the required time frame. Please recognize that years from now, that link may no longer work. Again, I want to thank the witnesses for their participation today. What we have heard is very valuable, and members of the subcommittee may have some additional questions for you, and if we ask the witnesses to please respond to those questions in writing, the hearing record will be held open for 14 days in order to receive those responses. I remind my colleagues that pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff or committee clerk within 7 days. The questions submitted must address the subject matter of the hearing. I will now recognize the ranking member for his closing statement.
Thank you, Madam Chair. As we've heard today, there's bipartisan agreement that the Department of Labor oversight of the Black Lung Disability Trust Fund has fallen short for decades during both Democrat and Republican administrations. I'd like to thank our two witnesses for their testimony. Ms. Brown-Boren summarized the GAO report that was released this morning, documenting past challenges and outlining recommendations to improve oversight of the coal mine operator insurance program and to ensure the trust fund is managed effectively. Director Harthway and the Office of Workers' Compensation Programs should be commended for initiating significant improvements to trust fund oversight and coal mine operator insurance authorization and compliance. While there's more work to do, I'm confident that the department is on the right track, and we look forward to receiving updates on progress OWCP is making to implement the GAO's recommendations. As I mentioned in my opening statement, I hope we can continue to work together with the administration to support common sense, workable, and innovative approaches to ensure that the trust fund is properly administered. Thank you, Madam Chair, and I yield back.
Thank you very much. I now recognize myself for the purpose of making my closing statement. Again, I want to thank Director Brown Barnes and Director Hathaway for joining us for this important discussion. When the Black Lung Disability Trust Fund was established more than 40 years ago, it was meant to guarantee minors with black lung disease access to the benefits and treatments they need. Yet, as the committee learned today, the combination of declining coal production, a resurgence in cases of black lung, the inadequacy of the coal excise tax, and the department's failure to ensure coal operators carried enough insurance to cover their liabilities has already plunged the trust fund into billions of dollars in debt, and it promises to get worse. As a result, taxpayers are on the hook for a growing share of minors' benefits, and minors and their families are hopeful that the red ink will not be steamed by the prospect of painful benefit cuts. That is what happened in 1981, and we don't want a repeat 40 years later. The Department of Labor's decades-long failure to hold coal operators accountable for their full share of black lung benefits is unacceptable. It is particularly offensive in light of the exorbitant bonuses coal companies pay to their executives, while simultaneously dumping their trust fund liabilities onto the taxpayers. We cannot continue to allow coal companies to privatize their gains and socialize their losses. I remained concerned that the Department of Labor's new approach will not adequately protect taxpayers or minors and their families, and I hope that it will implement the recommendations included in the GAO's analysis. I look forward to working with the department and with my colleagues in Congress to ensure the long-term sustainability of the Black Lung Disability Fund. If there is no further business, without objection, the committee stands adjourned.